Hi, ACLU members and supporters. My name is Kelly Simon. I use she, her pronouns, and I am the interim legal director for the ACLU of Oregon. The country has been talking a lot about the Portland protests over the past few months. So I wanted to take a few minutes to let you know what we've been up to. Immediately after Minneapolis police murdered George Floyd, Oregonians, like people across the country, took to the streets to demand an end to racist police brutality and a new vision for public safety, one that values the lives of Black people. The streets, where our right to dissent is most protected. One chant you will often hear in Portland streets is, "Whose streets? Our streets." Portland police, like their peers everywhere, responded with more racist police brutality. In Portland, they blanketed protests with tear gas, hit press with impact munitions, arrested medics there working to keep everyone safe, stole the belongings of community mutual aid providers, like a group who showed up to cook for protesters. This was all before the federal government arrived. The federal police officers arrived as we entered July and brought escalation on top of escalation. Even though a local organization called Don't Shoot Portland had already won a restraining order against Portland police use of tear gas, the feds brought more tear gas. And even though we at the ACLU of Oregon had already won a restraining order against the police in Portland for targeting journalists, legal observers, the feds shot and arrested journalists, legal observers. What we have been bearing witness to in Oregon is nothing short of an unconstitutional nightmare. We are seeing people shot directly in the head, causing skull fractures, shot repeatedly in the back, causing large and painful bruises. People are being dragged into unmarked vehicles and swept off the streets with no explanation and not even knowing who's taking them or where they're taking them. The police tactics that we've seen, anonymous policing, disappearing people through violence, or snatch and grab tactics, shows of force, taking prosecutions away from our locally elected DA and pursuing charges against people that our DA has said are not a threat to public safety. These are all tactics we've seen law enforcement use to intimidate, control, and devalue the lives of Black, Brown, and Indigenous communities for centuries. And the Department of Homeland Security, while not centuries old, certainly is familiar with these tactics. And these tactics have no place in a free society. They fly in the face of our country's founding constitutional principles. Principles of freedom of speech, freedom of assembly, freedom of the press, the right to petition our government for a redress of grievances, of due process, of a presumption of innocence, of prohibiting excessive force and unreasonable searches and seizures. The actions by police in our country right now are raising high the specter of authoritarianism, of fascism. Threatens the beautiful people power that gives us hope for real progress toward the democratic dream of freedom and justice for all. They beg us to ask the question, whose government? And the ACLU is fighting to be sure the answer remains our government. We the people. We are in the courts, defending the rights of protesters, journalists, legal observers, medics, and we aren't even done filing yet. We are asking the Department of Justice to investigate the blatantly unconstitutional conduct of our federal law enforcement officers. We're urging Congress to rein in the tools and tactics we've witnessed, demand that DHS be dismantled. We are asking local and state lawmakers to divest from police and reinvest in communities, especially communities of color. We are telling the United Nations to scrutinize the Trump administration's threat to basic human rights. The ACLU's ability to respond so quickly and comprehensively to these threats is possible because we believe in the power of people like you. Thank you for being in this fight to save our democracy and to make Black lives matter in this country. All right, I have to get back to work for now. I'll see you in court.
All right, so I'm going to go ahead and start with just some housekeeping. First of all, welcome to everybody to Know Your Rights When Protesting. My name is Carrie McCarter. I am the Senior Paralegal for the Maine Human Rights Commission. I do want to let everybody know that this presentation is being recorded. We do plan to post it so people are able to watch it later and share it. Okay, so thank you all for joining us. Thank you to the ACLU for participating and for doing most of the organizing, especially the ACLU's Director of Communications, Kainat. It's been a really scary and confusing time, and I think it's approaching the next election. It's only going to get scarier. One thing we can do to help protect ourselves and others is to become more familiar with the legal protections that we have. The ACLU has lots of helpful videos on their website. They have a whole Know Your Rights series. I encourage you to watch them and rewatch them. I know I certainly go and do that. And I will put the link to that page of their website in the chat. The Maine Human Rights Commission also has information about discrimination on our website, including in places of public accommodation. I will put a link to that in the chat as well. You can start the process to file a discrimination or retaliation complaint right on our website by filling out an intake form. So just a quick rundown of our agenda for the day. Our first presenters are Emma Bond, Legal Director of the ACLU of Maine, and Zach Heiden, Chief Counsel at the ACLU of Maine. They're going to be talking about knowing your rights when protesting, when stopped by police while protesting, and when taking photos or videos at a protest. Our second presenter is Defense Attorney Logan Perkins of Perkins Law Office, who will be talking about what protesters should know if they get arrested. I know I always have our commission counsel's cell phone handy, but I probably can't give that out to everybody, so be interested to see what other suggestions Logan has for us. And finally, our last presenter is Barbara Archer Hirsch, Commission Counsel for the Maine Human Rights Commission, who will be talking about what is covered under the Maine Human Rights Act, which is much less than we would like. Today, you are hearing from and have the opportunity to learn from several brilliant legal minds. However, and you're going to hear this multiple times today, they are not providing legal advice in this presentation. Please put any questions or comments you have in the chat. We ask that you remain muted, and we hope to have 5 to 10 minutes at the end to answer questions or respond to comments. With that, I'm going to hand it over to Emma and Zach.
Great, thank you so much, Carrie, and thank you all for joining us on this beautiful Friday afternoon. Let's see if I can successfully share my screen now. Show you our presentation. So, like Carrie said, I'm Emma Bond, and I'm joined by Zach Heiden. And today we're going to be talking about your rights while protesting, what happens when you're face to face with a police officer, what your rights are with recording, with taking photos at a protest. We've got that lovely disclaimer, as always, that this is not legal advice, like Carrie said. We'll also cover technology and privacy while you're protesting, because we all carry around in our pockets these tracking devices, essentially. So what does it mean to protect yourself and your privacy when you have these tools that we all carry around with us? And last, we'll finish with some safety tips. How to keep yourself safe as much as possible and when you're protesting, and what this all means in the COVID-19 pandemic. And before we launch into the Know Your Rights information, I wanted to take a moment, and it's important to take a moment to recognize, why we're all here talking about this. We are in this moment of historic change and protest by Black Lives Matter, by amazing organizers of color all across the country, and we're in this moment of outrage about decades and decades of police brutality, of racism, of systemic racism and of white supremacy. So it's just this moment of reckoning in which there's been protests across the country, and we know in this moment with the lack of charges filed against the officers who killed Breonna Taylor, that these important protests are only continuing. So what does it mean? So it's an important time to know, what our rights are and what protesters' rights are in this moment, and hold that knowledge close. Knowledge is power. Exactly like Carrie said, we've seen also law enforcement crackdowns, local law enforcement, federal law enforcement, including in the other Portland. So we had this awesome video by Kelly Simon, legal director at the ACLU of Oregon, saying some of what they're doing, some of their legal actions. But we could play it, but you wouldn't be able to hear the words she's saying. So we're going to hold off on that and post it on our website so you can watch that later. So we're going to start with some basics about where the protest right comes from. Why is it that we have this right to protest? So Zach, I think you were going to take this away on this section.
Sure, thanks, Emma. My name is Zach Heiden. I'm the Chief Counsel at the ACLU of Maine. I use he, him, his pronouns, and it's a real honor to get to speak with you all today. The First Amendment protects a number of rights that all, as a constellation, really add up to the right to protest, right? Freedom of speech, you get to express yourself. You get freedom of association, you get to get together in a big group to express yourself. You have the right to petition your government for a redress of grievances. Maybe you can get together with a bunch of people to try to get the government to change its behavior. And then freedom of the press, because it's much more helpful when you can get publicity and get attention for your cause through your protests. So all of those are protected right in the First Amendment to the US Constitution, as well as in almost every state constitution, including the Maine state constitution. So the First Amendment speaks about freedom of speech, but that actually over the last 100 years has been given a very expansive reading. It protects pure speech, getting up and giving a speech, but it also protects other forms of expression, holding a sign, standing silently, witnessing an event for expressive purposes, wearing an armband or engaging in other kinds of expressive conduct, and even artistic speech, like doing a dance or singing a song. Those are all protected under the First Amendment. There are some activities that even if your intent is to do them for expressive purposes, like destruction of property, that are not protected in the First Amendment. We're not here today to tell you what conduct to engage in or not to engage in, but we do want to help you understand what are some things that the First Amendment is going to protect you if you do them, and where are some areas where the First Amendment's not going to protect you if you do them. And civil disobedience is that second category.
And so, okay, so we know we have this right to free speech, and where can I exercise that right? Sidewalks, private property, where are some places where I can engage in that sort of protected activity?
Yeah, when we think about a protest, maybe we think about a march down a street, or we imagine a gathering on the mall in Washington, D.C., or some other public square. The places where your right to protest are strongest are what's called traditional public fora. And that's streets, sidewalks, parks, public squares, places where people have traditionally gathered to express themselves with people who share their views. Other places may technically be public property, like a government building, but your right to protest isn't as strong in those places as it is outside in Monument Square or outside of the Capitol building.
Do I have to get permission before I can protest, or can I just go out and express my views?
Yeah, the answer to this, like many legal questions, is sometimes. There are rules for permitting. If, for example, you're going to have an enormous crowd or you're going to march down the street and block traffic, cities are even allowed to require you to pay for the police protection to make sure that cars don't run you over and that the traffic is controlled. But it's important to know that you have an emergency right in the First Amendment to engage in free speech activity in response to, an immediate late-breaking story. Something happens on the news, and people want to, sort of pour out into the streets. The government isn't allowed to say, well, you didn't get a permit a week ago, so you can't do that. The freedom of speech and freedom of assembly trumps that right.
So, for example, when just recently we've seen people have been, people learned about the decision not to charge the officers who killed Breonna Taylor, and people were sort of instantly out on the streets. So might that be an example of this other situation?
Yeah, that's a good example. And another thing connected to this is that even if there is a permit requirement in your municipality, and you can find that out by calling your city office or your town office, they generally have to leave open some free channel for communication. So if they say you need a permit, you need to pay for it to march down the street, they have to say, well, it's free if you want to go meet in the park or in the public square.
What about protesters and counter protesters?
Sure.
Whether you're a lot lately.
Yeah, whether you're a protester or a counter protester is often just in the eyes of the beholder. The essential rule is that governments are allowed to say, regulate the time, place, and manner of an event. And consistent with that, if they say like the first group to get to a space has that space, and that group is then allowed to exclude others. But counter protesters also have rights, and generally that means the government has to let them be kind of within sight and within sound of the event that they are counter protesting. But police will often try to keep the two groups apart, and courts will recognize that that's legitimate government interest. Governments can shut down protests. They can order an end to them. They can say that it's over. But there's two important rules with regard to that. One, they have to have a good reason, right? And the fact that you're protesting the police and the police don't like hearing that, that's not a good reason, right? The government can't shut down a protest because it doesn't like the message. There has to be some independent safety, content neutral concern. And second, if they're going to order people to disperse, they can't do it, quietly and then 5 seconds later start arresting people for failure to disperse. They have to give people adequate notice. It has to be loudly communicated and make sure people have time to comply before they start arresting people for non-compliance. I'm sure Logan's going to talk more about that issue. So, Emma, you're going to talk a little bit, I think, about, when things don't go great. You're at your protest, you're doing everything you thought the First Amendment protected you to do, and yet you still find yourself being questioned by a police officer. What do you do in those situations?
Sure. So, in that moment, if you are at a protest and you find yourself or the group of people that you're with being confronted by one or more law enforcement officers, by police officers, that's going to be a stressful moment, and probably not the time that you're calling to mind all of the, maybe cases that or legal authorities that So what we always say, and for myself as well, this is what I would do, is remember three things. First, and repeat as much as necessary. So the first thing is ask, am I free to leave? And if the police officer says yes, you leave. You just walk away calmly. And it's important that you can repeat that. You can ask, am I free to leave? 30 seconds later, am I free to leave now? A minute later, can I leave now? And if at any one of those questions, the police officer responds yes, you leave. Second, you can say, I do not consent to a search. And this is important because officers often sort of rely on the lack of lack of clarity in that moment and try to say that you agreed to something you didn't do. So be really clear. I do not consent to a search. And say, I am exercising my right to remain silent. And then remain silent. that last part can be challenging.
Yeah, it's important to say it, and then it's important to do it.
Yeah, so, you know, knowledge is power. So I'm just like Zach provided the First Amendment explanation, I'm just going to provide a really quick explanation about the constitutional rights that govern these three rules that we've given here. It's basically the Fourth Amendment to the Constitution and the Fifth Amendment. So the Fourth Amendment says that law enforcement can't engage in unreasonable searches or seizures. And the Fifth Amendment is the right against self-incrimination. And now there are lawyers in courtrooms across the country every day who are arguing about, you know, what it means, whether something complies with the Fourth Amendment or with the Fifth Amendment. But what's important for, you know, you to know and to empower your actions in the moment is that generally the Fourth Amendment requires officers to have some justification if they're going to stop you, if they're going to limit your movement, or if they're going to search you or any of your belongings. And so that's their obligation, or they have to get your agreement. So the important thing in these interactions is that you're not agreeing to anything that you don't have to. So that's why, you know, by asking, am I free to leave? You're not agreeing to stay there and talk to that officer unless they, you know, require it, unless they have some justification. Same thing. You're not going to agree to the police officer being able to search your bag or search your belongings. You know, they have to have that justification on their own. And same thing with the right to remain silent. You know, you're not going to give them any information you're not going to give them information to help them out, essentially. And one interesting thing that Zach is going to speak a little bit more about is, you know, there's a lot of things, like when we say exercise your right to remain silent, you know, that has some implications for technology too. So if you have your phone, is it a good idea to set your phone up so that it doesn't, you can't unlock it with your face or your finger? Set it up so that you have to enter in a number to unlock it. So that if you're in a position where the law enforcement officer is asking you to unlock your phone, you could exercise your right to remain silent and, you know, decline to provide the numbers to unlock your phone. So that's, and like I said, Zach will be talking more about other interesting ways that, you know, technology intersects with our rights with protesting. What if your rights are violated? You know, these are the rules. Officers violate them all the time. You know, that's some of what Kelly Simon from ACLU Oregon will be talking about in that video that we'll be posting. So document. You know, using whatever you have. If you have a pen and paper, write it down. If you have your phone and you can access it, you can video. Just document what's going on so that you can, you know, enforce your rights later in court. And Logan will speak about this more. If you're arrested, exercise that right to remain silent, unless it's something that could, you know, get you out of jail, like a bail bond, or something that prevent you from going to jail, like a summons. So those will be the only two caveats to that. So now we get to the part about technology and privacy. You know, what special rights does this ability to have a camera and record give you, but also what are some of the privacy concerns and you know, how to protect that during a protest.
Yeah, and like so much of our life right now, you know, a relationship with technology is complicated, right? So the undeniable benefits that we get to all talk together right now and be together, even though we're all spread out across the state and country. But it also can be used against us, and it's certainly true in the protest context that is sometimes the case. Let's talk about the positive first. One of the great developments of the last 20 years has been that people carry around cameras and now high-powered, high-definition video cameras with us, you know, all the time in our pockets. And along with that has come the recognition that the First Amendment protects your right to record the police when they're doing their work in public. So when, you know, the police, if they're mistreating somebody, and we've obviously all seen videos of that, or if they're violating people's First Amendment rights at a protest, that also can be videoed and then shared and can lead to, we hope, changes in behavior and in policy. It's a very powerful right. and we have, these tools that we all carry around with us that we need to make use of. In the hopes that they will make a difference.
Yeah, and we've seen.
Yeah, sorry, go on.
Just quickly, we've seen how, in some ways, people don't understand the ways that police treat communities of color, and so it's been transformational for videos to actually require people to confront the ugly reality of what systemic racism looks like on a day-by-day basis. So, videos don't lie. Well, sometimes, but they can be edited. But I mean, that ability to confront people with the reality has been so powerful.
Yeah, the one issue to remember with this is that you're not allowed to interfere with police while they're doing their job. So you may have to stay back a few steps or a few feet and not get in their way. But you're allowed to be a witness and you're allowed to record, and that is protected under the First Amendment. Now, interestingly enough, that the way that right has developed has really come out of this part of the country, out of New England and Massachusetts. The first important case to deal with this was actually about a police officer who was in the Boston Common, and somebody was videotaping them, one of the most traditional of traditional public forums in the United States. So now the cautionary note. Technology, while it gives us tremendous benefits, it can also be used against us. And part of, the heart of that is two things. Number one, we carry around with us an enormous amount of information about our lives and our behaviors and our friendships and our personal relationships and our health on these phones. All information that could be used against us in any number of ways. And number two, in order to work, these phones check in with a cell phone tower every 8 seconds, and they're also equipped with GPS to help us find the shortest way to a restaurant or bar. And that means that the cell phone companies have a very detailed information about our movements and who we interact with. So people who care a lot about privacy, and maybe more about privacy than they do about free expression, don't have cell phones, or they don't bring them to protests. But then you're missing out on the opportunity to photograph and video and record things that are going on. So to try to find a middle ground, there are some steps you can take. First, always keep your cell phone locked. Have it in airplane mode whenever you can. Use a very strong password and use encryption. Whatever encryption is available on your phone, use it, and make sure you have a strong password that's difficult to crack. If you're going to be communicating, excuse me, use an encrypted messaging system. We use Signal, but there are a number of them. Signal is available for free for download. It's endorsed by ACLU client Ed Snowden. You can put up group messages, but there are any number of encrypted messaging programs that'll just keep your communications a little bit more secure. Those are just some steps that you can take that will help protect your identity and your privacy while you're protesting if you have your phone.
Great. So the last section of our presentation before I turn it over to Logan is to talk about common sense and safety. And what this really stems from is the reality that even if people are acting completely within their rights under the First Amendment, even if they've complied with any applicable rules about permits, even if people do everything to the letter of the law, there is still the possibility, and we've seen it across the country, that law enforcement, police officers will engage in police brutality or will arrest people without any appropriate reason. There's no ability to prevent necessarily in the moment. That it's the reality that can happen. And we also know that there can be particular risk for people of color. You know, they're well documented that if you are a person of color, that you may be at higher risk for this sort of thing. And likewise, the risk for arrest, the risk associated with arrest may be higher if you are undocumented. You know, that just has additional implications. And, you know, now is maybe a good moment to say, you know, if you are someone that is undocumented, or if you have a green card holder or some other type of status, it is definitely a good idea to speak with an immigration attorney to just cover the bases. It's a you know, complex area of law, but before you're going out and protesting, just to cover all your bases and make sure that you are protected. But you know, recognizing these things and these realities doesn't affect what people's rights are. You know, you can always go into court and argue your rights, but that, you know, doesn't take away from the very real dangers that people could face in the moment. So it's really important that everyone decide for themselves, you know, what they feel comfortable doing and what they want to do. You know, that's an individual choice, but one that, you know, that people should be aware of what the potential risks are. And so we have a link here that is on the ACLU website. I hope everyone can see the full link, but it's a really powerful video, and we don't have time to go through the entire video here, but I hope you'll take a look at it when you have a moment. This is just a screenshot of the video, but it's this really powerful sort of dance video that was put on to explain not only what people's rights are, but the intersection of how to stay safe in the moment, as safe as possible, and protect yourself when people may be in situations that that could be dangerous for them. So I really encourage people to take a look at that and just always, you know, stay safe and do what you individually feel comfortable doing. So we also live in the time of COVID, and you know, protests can pose special, you know, can make social distancing challenging. So, you know, mask up, have gloves, you know, physically distance as much as possible. Now, if you're someone who's having symptoms, or you think you could be positive, stay home. You know, don't expose people. Don't put other people at danger. You know, you can express your support of these things in a lot of different ways. If you live in the city, put up something on your window. You know, then speak out on social media. There's a lot of ways. If you are someone who's symptomatic or who could be symptomatic, you know, keep yourself safe, keep other people safe. Or, you know, if you're medically vulnerable in this time and becoming infected with COVID could be particularly dangerous for you, again, there's many, many ways to stay involved and to express your views. If you do test positive for COVID, or you do get symptoms after a protest, you know, often, you know, try to stay in touch with the organizers, let people know. It's a respectful thing to do. And there's another link here if you want to get tested. There's a link of how to get more information about COVID testing. So that is the end of what Zach and I had to present. And up next is the very fantastic Logan Perkins, a brilliant legal mind and a great leader in the area of representation for protests and protest rights. So I'm going to turn it over to Logan and stop sharing my screen.
Well, thanks, Emma. I think you've overstated the case a little bit, but I'm going to do my best for y'all today and always. So I wanted to just say a couple things about Emma and Zach's presentation, which is that, you know, the rights that they've described are rights not just limited to protesters, but for everyone, and for everyone every day as we move through the world, at least in this country. But these rights are, we like to say, use them or lose them, right? In other words, you have to know these rights, you have to assert these rights, or else they really do go away, right? So the search, refusing to consent to a search is a great example, and Emma made this point, but asserting that you're not going to consent to a search is a really important way to protect that privacy right. If you don't say, I do not consent to this search, then the police and later the prosecutors are going to be able to say, well, they acquiesced, you know, they agreed to the search by not objecting to the search. So it's really that bad that you have to actually be assertive in this way to do that. And the reason I want to start with that point is because I'm going to shift now into what happens once you get arrested. And unfortunately, one of the things that happens once you get arrested is that you get searched, and you don't have the right to refuse that search, although I would always continue to comment that you don't consent to a particular search. And that search is what's called a search incident to arrest, and is very broad search authority that the government has that goes to you, your person, including in many cases body cavities, as well as any belongings you have on you. So bag, backpack, purse, wallet, any of those kinds of things, and your cell phone, right? So certainly anything that's on what we would call plain view in your cell phone. So let's say you have your cell phone, it's on, and it's set to just pop up on the screen anytime someone messages you, right? And you get arrested at a protest, and then your friend texts you a photo of your other friend holding a Molotov cocktail about to throw it at a police officer or at a vehicle or at City Hall or whatever, that is now evidence that's in the hands of the police, right? So this is an excellent example of why you want that phone shut down, locked. You want to shorten the time that it takes for your phone to lock if you haven't touched it in a little bit. You want to make that basically immediate. And you want to set your settings on that phone so that messages and banners and notices aren't popping up even on the locked screen, right? So you want to disable all those notification banners that sometimes pop up, so that when your phone is in the custody of the police, because you got arrested with it in your pocket, they don't have a steady stream of evidence from your friends all texting you about all the good trouble they're up to on the outside coming into the hands of the police. So once you are in custody like that, you still have all those rights, right? And I would encourage folks to really insist on those rights, including in particular the right to remain silent, which is a twin to, or sort of like attached to your right to counsel, right? Which is that you don't want to talk without a lawyer, and that is actually the most powerful form of that right. And applies particularly when you're in custody. It's a very strong right. So if you assert that you want to see a lawyer or that you don't want to answer questions without a lawyer, then they're not supposed to even approach you to begin questioning you again for 2 weeks, right? So that's the sort of general window that you buy yourself when you assert that right and you're in custody. So I want to shift gears a little bit and talk about a couple of things that Emma and Zach promised I would talk about, one of which is this pattern that I've seen in my practice locally in Maine, which I think is actually very, very common, which is that the pattern by which we see law enforcement attempting to disperse protesters, attempting to put a stop to civil disobedience, but also just mass gatherings, including in those traditional public forum, like on sidewalks and public locations. One thing I think the police do routinely and have not really figured out that it creates, arguably a fatal flaw in any prosecutions based on that, is a lack of that notice and opportunity to comply with those notices. So I can just say in my practice, I saw that and successfully used that as a defense in a trespass case for a bomb train protest that took place in Lewiston or in Auburn back in 2013. My client was arrested for trespassing on the railroad tracks, attempting to blockade a bomb train. Folks might remember the tar sands oil trains that blew up Lac-Mégantic. Same trains are running through downtown Auburn. This is obviously a racial justice issue as well as an environmental issue. And this blockade was taking place, and the video we had, which was taken, I believe the video in that case was actually taken by our people, showed really clearly 16 seconds between the officer's order for her to get up and leave the tracks and him picking her up and arresting her. So we argued, and I think it persuaded the jury, that 16 seconds was not a meaningful opportunity to comply with that order, right? That the average person needs to process that, needs to think about that, needs to weigh their decision before deciding what's going to happen next, and that 16 seconds isn't enough. I just recently had a client who was part of the BLM arrests from June in Portland, who sent me a video, also that one of our people took, of police massed on the corner of Franklin and, what is it, Middle, that goes by the Portland PD, and these folks standing like on the corner away from PD, 4 or 5 folks standing on the sidewalk. The officer says, "You got to get out of here now." My client just turned his camera on and started recording, stayed on the sidewalk. The officer arrested someone who stepped off the sidewalk to try to talk to them about why they were being told to leave. They weren't even in front of the police department. They were like a half a block away. The officer arrested that person and then came onto the sidewalk, grabbed my client, who was in the process of videoing that police interaction, and arrested my client. And luckily there was a third person standing another like 15 feet up the street videoing the whole thing. So my client and the other person arrested there were charged with failure to disperse, which alleges that they were engaged in a course of disorderly conduct, were given a notice to disperse, and failed to comply with that order of dispersal. And again, it was really fast, and it was totally unclear what that order covered, right? Because they're standing on the sidewalk, they're out of the way of any police operations. The police, meanwhile, are blockading all of Franklin Street. And, you know, somehow my client standing on the sidewalk with a cell phone recording is the problem, right? And is engaged in disorderly conduct. So I would say that is a pervasive theme that we see, is that police give overbroad orders to disperse, orders which aren't really justified by any legitimate governmental interest, and orders which extend to traditional public forum, which should include the most protected areas for engaging in speech, and orders which extend to sort of non-disorderly, non-disruptive, peaceful First Amendment activity, which was clearly what was on display in this video. And those cases were all dismissed by the Cumberland County District Attorney's Office. I mean, we don't really know why, other than that probably they're seeking to keep the peace in the city, but certainly that's a pervasive pattern we see here. So, and then I just wanted to speak quickly to, and really what maybe I'll just do is give you guys a list of what I think are the other sort of repressive policing tactics that we've seen on display in response to protests and activism and organizing around the country, so that we're sort of aware that those are out there. Maybe those are a conversation for another day, but I did want to raise some of them. So one big tactic we've seen is the use of federal prosecutions and extreme federal charging decisions, like terrorism charges for protesters. A great example of this is the 2 folks in New York City, and I'm going to apologize in advance because I don't know that I have this pronunciation right, but Colin Mathis and Uraj Raman, who were attorneys in Brooklyn, who were charged with basically throwing a Molotov cocktail at an empty NYPD cruiser, who are now facing federal explosive charges and terrorism charges with a 45-year mandatory minimum, right? No one was in this police cruiser, right? So let's be clear that under state law, that's arson, right? Maybe that's arson, or some sort of high-level property destruction. But under federal law, because it's targeted as a government entity, it's got terrorism enhancement potential, and it's got these federal mandatory minimums associated with it. So federal prosecutions, we see repressive tactics post-arrest, including interrogation tactics, which will often seek to impose a prisoner's dilemma scenario on protesters, which is basically like rat out your buddy before your buddy rats you out. The threat of conspiracy charges, which also can be a way for a case to go federal or to get federal prosecution status. The use of grand jury subpoena for intimidation tactics. A great example of this is Chelsea Manning just did a year and a week in federal prison for refusing to comply with a grand jury subpoena, which was used as a way to try to investigate Julian Assange and WikiLeaks. We see the use of arrest without probable cause or without legitimate probable cause as a way to just terminate First Amendment activity. I think this is a tactic we're likely to see more and more because it's a particularly difficult tactic to defend. Probable cause is a very low standard and doesn't necessarily take into consideration a First Amendment defense. So broad or mass arrests as a way to end First Amendment activity. We see high unreasonable bails, particularly targeting who are perceived as leaders or the most vocal advocates in activist circles. And then down the road, we see really punitive prison classification and prison treatment for particular activists. A great example of this is Daniel McGowan, who served a domestic terrorism sentence related to some environmental activism, who was housed, I think, for 7 years in what's called a communication management unit, which is really used for terrorists to prevent them from communicating with the outside world, and was used, it really limits access to attorneys, to family, to supporters, and to any kind of media or other communication. So there's a long list of repressive tactics available, and it's something I think that activists and protesters need to be aware of and need to be thinking about how we might respond as a community or how we might organize around those issues when and if they pop up. I'll stop there. Oh,
that was
answer that
amazing.
question. I just saw the question in the chat.
Oh, that's what we can hold it to the end. We have Barbara Archer Hirsch, Mission Counsel. Hand it over to Barbara.
Great, thanks. And I will be relatively quick because we have the least practical advice to give to any of you. And Logan, Zach, and Emma already covered some great content. I just wanted to look at things from sort of a different angle. What the Maine Human Rights Commission is an independent agency, quasi-independent, and we enforce the Maine Human Rights Act, which prohibits discrimination in certain areas of your life, like employment, housing, and what's important to this discussion, places of public accommodation. So we prohibit discrimination based on your protected classes. So those are things like your race, your color, national origin and ancestry, sex, sexual orientation, and disability. Great, Barbara, what does that have to do with protesting? I'm going to do my own Q&A because I don't have like a Zach and Emma situation happening. So Zach and Emma talked about traditional public fora where you can engage most safely in your First Amendment activities. So places like public streets, public parks, roads, municipal buildings, voting sites. Those are all places of public accommodation, which are covered by the Maine Human Rights Act. Police officers and police services, so the police, while they're out in the streets providing services to the public, are also public accommodations. And what the Maine Human Rights Act provides is that you can't be denied access to public accommodations or be treated differently in your access to the goods and services offered by these public accommodations based on your protected class status. So that's something that we see certainly in the news, if not on the ground, when looking at protests. So one example would be you can't refuse a permit to BLM to protest if you are permitting, say, a white supremacist group to protest. So you can't discriminate based on race in deciding who can protest and how they can protest. The Human Rights Act includes discrimination based on association with people who are in protected classes. So not just if police treat you differently because you're a person of color or because you're wearing a hijab and they presume that you are Muslim because of how you look. That is obviously discrimination based on your protected class, but you can also, if the police treat you differently because you're associated with people in protected classes. So if you are, for example, a white person who is protesting on behalf of or as part of the BLM movement, if you're treated differently when compared to, for example, a white supremacist counter protester. Those are things that are covered by the Maine Human Rights Act and that will enable you to file a complaint with the Commission about discrimination. The one thing I did want to flag under the Human Rights Act is that you can be denied access to places of public accommodation if your participation poses a direct threat to the health or safety of others, and that's defined by the law as a significant risk that can't be eliminated by modifying policies or practices. So this is a defense that the police or law enforcement might use if protests turn violent. It's important to know that determining that somebody poses a direct threat has to be an individual assessment. It can't be based on assumptions and stereotypes on groups. So if they can't say, well, we know BLM is violent, they have to look at the actual impact of what's happening on the ground in order to use the defense. So I need to stress here that the Commission is not an advocacy group. We are a neutral agency. We're complaint driven. We can't provide legal services or representation. What we do is we receive complaints about people who feel that they've been discriminated against. I should also flag that we have limited authority. We can take complaints about things that state law enforcement or state actors do, but nothing about federal action. So what we do is if you're at a protest and you feel you've been discriminated against, you can file a complaint with the Commission. There's nothing immediate that happens when you do this. It's not a get out of jail free. It doesn't get Logan to show up to help you out. It might not be what you need in the moment, but I'm still going to encourage you to file or at the very least fill out an intake form. And I know Carrie's shared our website and maybe Carrie, you can share the direct link to our intake page. You've got up to 300 days from the date of an incident to file a complaint with us. And even if you don't want to go forward in your name, or you start a complaint and decide that it's not something you want to pursue, depending on your personal situation, if the Commission is hearing from enough people who are seeing discrimination and are witnessing this on the ground, the Commission staff has the ability to file complaints in their own name. So what we're seeing is a pattern or practice of discriminatory enforcement. We can file a complaint ourselves. And the only way for us to do that is if we hear from people who are there who feel like they're being discriminated against. So even if you don't want to file a complaint, there are things you can do. I'm going to echo what Logan said and what Zach and Emma said about collecting evidence. Take pictures, make recordings, jot notes so that you can back up any complaint you file with us. Comparator evidence in particular is good. So if you are witnessing someone who's being mistreated based on their color or their national origin or their disability or their sexual orientation, if BLM is being forced off the streets, but white counter protesters are allowed to block traffic in order to get in their faces. Those are things that we would want to hear about. And again, fill out that intake form whether you want to follow through ultimately on a complaint or not, because that's what will let us get the big picture and maybe be able to take some systemic action. So that is what I have. And if there are questions, obviously, we'll turn this over to Carrie to send them out.
Yeah, so we had a question earlier. What is the proper response to police saying that bystanders cannot record something that's happening? I don't know who wants to take that.
I think Zach has litigated those cases, so I think Zach should handle that one.
Yeah, so I had a couple of cases like that, and the one thing I'll say is there's no proper response. We're trying to help you make an informed decision about what to do when you're having an interaction with the police officer, but what you decide to do is going to be ultimately up to you, and it may have consequences. I had clients who were recording the police engaging in police behavior in public, and they were told to stop recording, to go away, and they didn't. They kept recording, and they got arrested. They got taken to jail, and they spent most of a night in jail. Now, ultimately, we prevailed in court, and they, got a damages award, and the city was, changed its policy and publicized its training that it was going to make sure people knew about those rights. But those people still had to spend the night in jail, even though they were right, even though they were well informed. That may be something you're willing to do. It may be something you're not willing to do. None of us on this call are going to judge you for either of those decisions. We're just trying to help give you information about what the Constitution says and what the courts have said about the Constitution.
Thank you for that. I've written down probably about 20 questions. But, so I guess the two big ones are, so the government building issue. So we're maybe allowed to protest on government property at a government building. How does that intersect with the federal police that are being sent to, like, Portland, Oregon, specifically to protect those buildings? Like, what does protect those buildings mean?
I'll jump in with some quick thoughts, and then I'd love Logan and Zach to hear if you have anything to add. But my first answer is that some of this, these are sort of new assertions of authority in some ways being asserted by the federal government, and so they're being worked out in court. So the response is that the assertion of rights by protesters and individuals is, yes, we have that right. No, pointing a flashlight or whatever it may be at a laser maybe at a federal building is not hurting anyone. This is all part and parcel of First Amendment freedom of expression, and that is working its way through the courts. So, Logan and Zach may have additional updates about, how those fights are going, but, it's important to recognize in many ways that the federal government is just acting out in new ways and pushing the limits of its authority. And that's because the protesters are really upending the status quo. And I think that's important.
So I can say that I've litigated 2 and have a 3rd case pending in Maine where essentially civil disobedience, nonviolent civil disobedience protesters have either, in one case, we're in Susan Collins' office in the federal building in Bangor, said they weren't leaving until they talked to the senator, stayed past 5 o'clock, and were arrested by the Federal Protective Service. Basically, were given an order to leave, and then when they refused to leave, were arrested by Federal Protective Service. It's a federal misdemeanor. As things go, it's not a huge federal charge. Up to 30 days is the maximum sentence that can be imposed. And we litigated that case and basically, said that they were, we tried to make a content-based speech defense to that case by saying that the state government had declined to prosecute charges for very similarly situated protesters who happened to be union members, AFL-CIO folks who had occupied her office, been arrested and removed, and then the state declined to prosecute those charges. These folks who were more like indivisible, like less like union, more like troublemakers, were, not that unions can't be troublemakers, we love it when they are, but were prosecuted by the feds, right? So we basically said that that was selective prosecution based on the content of their speech, that they were somehow seen as more trouble or less respectable, and therefore were prosecuted by the feds as a way to deter future occupations of Senator Collins' office. We lost. They were convicted and sentenced. And then we have another case which we litigated last year and lost also, but we tried the same exact charge. Federal Protective Service issued an order to disperse to folks who were trying to enter the Customs and Border Patrol building in South Portland to talk to Maine CBP officers about enforcement of the family separation policy that ICE and Customs and Border Patrol have been carrying out, and were denied access to the building even, right? We're not even allowed to approach the building, enter what's a secured foyer where they could report their business, right? Their business or their concern to a central receptionist who could then tell them, sorry, you need an appointment, or sorry, we can't deal with that issue here, you have to leave. They weren't even allowed to approach and make that inquiry in the foyer. And we argue that basically Federal Protective Service created a prior restraint on their speech by refusing to let them even approach the building to be screened to see whether or not their concerns were appropriate subject matter to communicate to those officers. And instead, by stopping them basically in the parking lot, they had violated their First Amendment rights, and it was therefore not a lawful order to disperse because it was in violation of their First Amendment rights, and that if Federal Protective Services had perceived these protesters to be folks who wanted to go talk to Customs and Border Patrol about, pandas being smuggled into Portland Harbor, they would have been allowed to approach the office, but because of the content of our folks' speech, they were prohibited. So Magistrate Rich rejected that. We lost. Those folks got community service. So, we're litigating those issues in Maine. There's basically the exact same fact pattern is pending again now in the federal court in Portland. I'd be really excited to hear from anyone, any ideas about how to address that, because it's the same issue, right? They weren't allowed to even approach the building. So Federal Protective Service has very broad authority to protect federal property, and that includes orders to leave. And so far in Maine, the federal courts have been willing to give them very broad authority to do that, even when it's, political speech-based issues. And totally nonviolent, I will say, like no laser pointers involved. Not that laser pointers are bad, but.
Thank you. So I'm just going to ask one more question. Like I said, I could keep you guys here for a while. So the purpose of this training presentation has been to help people to understand their rights. I'm wondering, in Maine, do you feel like the people who have authority, police officers, I guess mostly police officers who are out, do they know these laws that what we're talking about right now? Or are you finding people that just don't know it that well?
So I'm no expert in exactly the ins and outs of police training, but it has come up in some cases what police learn at maybe the Maine Corrections Academy, or there's an academy where people get trained on how to be police officers, and definitely they are trained on that there's a Fourth Amendment that they have to comply with, and that people have these constitutional rights. Now, is it? I can't really go any farther than that, except to say that sometimes there's the training you get in that one instance, and then there's the training you get from watching what your other officers are doing, or watching what people do on TV, or seeing what sort of practices exist that just kind of grow up over decades. And those sorts of day-to-day training that they get every day on the job can be, can create some harmful practices that maybe are really different than what they learned at the police academy.
Yeah, that's definitely been my experience. I mean, I think there is certainly an under education of officers with respect to First Amendment issues. I think they are broadly trained on Fourth, Fifth, and Sixth Amendment issues, but they're under trained on First Amendment issues, has been my experience.
All right, well, thank you all. Would anybody like to add some final thoughts?
Thank you, everyone. This was a great conversation. Really appreciate it.
Yeah, we will, once I have the recording available, we will, I believe the ACLU is going to post it on their website. Commission will post it on our website. I'm just trying to make sure people have access to it. Thank you all for coming. Thank you all for doing this. I really appreciate it. You've all been very informative and just, this has been great. Thanks so much.
Thank you.